Hello, hello. Welcome, everyone. Thanks for joining us. We have a super dense and important and informative webinar for you guys today. I'm joined with a friend of mine, Brad Miller, and he's going to talk to us about contracts, everybody's favorite subject. If you are like me, contracts may be kind of scary to you, and you may have a lot of questions, in which case we would love to save some time at the end of this for Q&A, and we will be doing that. So feel free to ask questions in the chat or in the Ask a Question section below the video, and we will get to that at the end of Brad's presentation. So stick through to the end. Brad has a lot that he's going to go through today, including the 9 essentials for your contract, every freelance contract, which I think will be super, super helpful. And I'm going to be taking lots of notes. This is a webinar that's part of the series of Unreal Collective member spotlights. Unreal Collective is an online accelerator for freelancers and founders to help you level up and take your business to the next level. So I've been lucky to work with Brad for the last 12 weeks. It's been a whole lot of fun. He's been on each of our calls the last 12 weeks, dropping a ton of knowledge to a lot of us freelancers and founders, which we're super excited about. So once again, remember, you can ask a question at any point throughout this period. You can ask it in the chat or in the Ask a Question section, and we'll get to that at the end. So Brad Miller, who is joining us, is the founder of Miller Law. He practices exclusively in the area of business law, focusing on small businesses, mergers, acquisitions, and franchisees. He'll talk more about that. He can introduce himself better than I can. And so, Brad, at this point, I'm going to turn it over to you if you want to introduce yourself and Miller Law a little bit and get into our presentation.
Thanks, Jay. Let me... hop in here. All right. So as a lawyer, I love disclaimers. Okay, not really, but did want to, before I get going here, make a couple things clear about this presentation. So first of all, nothing in this presentation should be considered legal advice. Everything that we're going to be talking about today is going to be kind of general legal information. It's not specific to you or any situation. The things we're going to talk about are areas that I've seen freelancers and entrepreneurs get into trouble with. I'm going to provide maybe some general recommendations of ways you can prevent some issues. Ultimately, though, after today, when you've got lots of questions and things like that, really you need to reach out to a business lawyer and have them go through your specifics. That's really the only way you can kind of really protect yourself on that. And the second disclaimer is that I am not your lawyer. Just because we are on this today does not mean that I am, representing you or there's any attorney-client relationship or anything like that. So again, need to make sure that I get that clear going forward so everyone's aware. All right, now on to the fun stuff. One of the biggest issues that I see entrepreneurs and freelancers, run into is not having any sort of a written contract in place. Something between them and their clients. Or sometimes maybe you'll have gone online, you'll have downloaded one of these free templates, or somebody else has got their agreement online and you kind of download it on the internet, put your name on it. And ultimately, because it's not really customized, it ends up being worth less than the price you paid for it. So my goal here in the next, and I'm really going to try to keep this at 30, 40 minutes, is to kind of impress upon you why it's important to have a written contract in place for your business. And then also give you some information about what you might want to have in your contract to make sure that you get that protection for yourself as well as your business. So as Jay mentioned, my name is Brad Miller. I am a business lawyer. I have been practicing now for over 10 years, most of that as a solo attorney, running my own practice. So I get what it is like to run your own business. It's what I do on a day-to-day basis. And so I totally understand where you may be coming from as a freelancer or, as an entrepreneur yourself running a business. Like I said, all I do is work with businesses, doing business law. I don't try to do divorce work or criminal work or anything else like that. It's all strictly business issues. Right now, my current focus is on franchisees, as Jay mentioned, and also helping people buy and sell kind of the smaller businesses. So obviously, if you have any of those issues, let me know. But I've been here in Columbus for almost 20 years now. I came for college, haven't ever left. Probably still stay in the area going forward in the near future or foreseeable future at that. So, and as Anna's mentioned, we do have a hashtag. So if you want to put that on Twitter or whatever, you can do so. All right. So for many entrepreneurs and freelancers, your business is the most important, valuable asset that you have. It might be your primary source of income. Maybe it's just what you do to supplement your day job. But it's going to be probably a big part of your life. And, especially if you're, again, on a solo person yourself and you've got clients that are going to be more established in business or more established and bigger than you, you're going to want to make sure that you've got protection of your assets in here. And really the best way to do that is to make sure you always use a contract whenever you're doing work with a client. Having some agreement in writing is important because it removes all the doubt, all the ambiguity, all the confusion about what each side is going to do. Everything is going to be written there in the contract. So like I said, it kind of sets out exactly what's going to be happening by each party in there. It removes any opportunities for maybe a less than upstanding client to take advantage of you. And again, especially if you're dealing with larger clients, maybe ones that are more experienced in business, have more resources behind you. There are opportunities where they see you as the little fish and they may try to take advantage of that situation. If you've got a good contract in place, you can help kind of remove that opportunity for them because they know that you've got these protections in place and everything, again, is set out in writing for you. Having a contract allows you to kind of pre-qualify. One of the reasons I hear from a lot of freelancers why they don't use contracts is because they're afraid that if you put a contract out in front of the client, it's going to scare them away, and they don't want to do that. But really, to me, if a potential client is not willing to sign a contract that sets out exactly what's going to happen, what the work is going to be able to do for them, that's a big red flag for me. You don't want to start working with a client who isn't 100% committed. And if they are not willing to agree to sign a sum of a contract, to me, that says that they're not really committed to what's going to happen. If they're hesitant to sign this contract, they're probably going to be hesitant to send you a check down the road as well. So better to get that out of the way up front than do all this work and then end up with problems down the road, maybe not getting paid for it. And a contract, it makes you look professional. If you've got a written contract in place, it shows that this is a business. This is not just a hobby. This is something that you've invested your time, your money in. You've got this contract. You've taken the time and to get that. You're serious about what you're doing. Contracts, besides that, also kind of to generate some trust in your prospect, your client. Again, it's in writing exactly what it is that you are doing for that client. And so they can hold you accountable for that. If it says that you're going to be drafting or creating them a logo, it will specifically say, look, we've got a logo here. This is what I'm going to be doing. And that's what they can expect from you.
Hey, Brad, I was going to ask you, and maybe you have this. So if this is later in the presentation, just let me know. Do you have a way that you recommend somebody introduce the contract into the conversation with a potential client, when that should happen, how you should introduce that in such a way that builds trust and makes them comfortable?
It's definitely important to have it in place before you start work. So if maybe the place that makes the most sense might be when you are, or right after you have gotten a proposal in front of them. So you've said, here's what it is that I'm going to be doing for you. Here's the price. And they've agreed to that. At that point, you say, all right, that sounds great. Let me get that written down. Let me get that put down into a contract and get it over to you to sign so we can get started working. And if you just make it, I think, part of this is the process, this is the way it is. And all I'm going to be doing is taking what we've just agreed to and just putting it down in place in this contract. I think that might help make it kind of an easier transition. You're not going to try to, scare them. You're not setting up any red flags or anything like that for them. If it's just kind of part of that natural process of it's just how we do work.
Yeah, it's almost making it like a non-event.
Exactly. Yep. And the last thing to do is that it helps, and the big part is that having a written contract in place is going to help protect your assets. Things are going to happen during the course of work on a client. Maybe they will decide in the middle of the project they want to walk away. Something's happened. Maybe their funding's cut. Maybe you get in a disagreement. Whatever might happen, and having this contract in place is going to give you the ammunition to make sure that you get paid for the work that you do, and it also gives you protection from liability if the client tries to come back on you or some third party comes and tries to come back on you. That's where you can use this contract to give that ammo if there's any issues down the road for it.
We got a question from Adam on that last point. His question is a proposal generally the same as a contract? And maybe phrased differently, could a proposal could double as a contract, or do you suggest two separate sort of documents and steps?
A proposal can be a contract. I would still suggest having an actual written formal contract in place after that. Generally, and maybe you make the proposal part of the contract, and then after that signed, you just have all the legal stuff at the end and all the different specifics in there. But to me, the proposal would set out the scope of the work, so what exactly you're going to be doing for the client, and the overall, either the price, here's the flat fee for it, or it's going to be $300 an hour, and here's about what we expect it to be. So really, you're kind of focusing in a proposal on the work and the price, maybe a time frame as well. Then when you do the rest of the contract, you'll have other things like liability protection. What happens if one party wants to terminate? The things we'll talk about here later on in the presentation. And so you can have them as kind of one separate and kind of included in there. But I definitely think that the written contract here that we're talking about primarily is something's going to come in after you've got your proposal agreed to already.
Yeah, I think to add on to that, I think a proposal, you want that to generate as little friction as possible for someone to say, yes, I agree with this scope of work and I agree with this cost. Let's move forward. At which point you have confirmation bias to make the next event of the contract a non-event. And just say, okay, great. Glad you want to move forward. This is the last step. Let's get going.
Right. Yep. Exactly. So, all right. So from speaking work with clients, there's definitely times when in talk with them, they wish that they would have had a contract in place. And so I kind of want to go through a couple of those situations for you to kind of let you think about, if it would, the benefit of having something in place during these, or maybe if you've run into these situations as well. You got a little bit of tease there of the first one. Everybody at some point was going to have a project canceled on them. Maybe the client's funding isn't where they thought it was going to be, and cash is going to be an issue. And so they need to stop the project now before they start incurring too much that they can't pay for. Maybe you have a disagreement with the way the client wants to go with it, and just the relationship isn't working out. Maybe the project is just something that is no longer a high priority for them. Maybe they hired you to do a new website for them, and through the process of that, it became apparent to them that this website was really not the highest priority for them at this time. They need to be focused on something else. And so maybe they said, you know what, we need to hold off on what we're doing now with you. So having a contract in place at this point, is a good thing to have so that you know how to handle those situations. Maybe the client has requested a significant change in the scope of work. You were brought in to take the current website to make it responsive for them. And now they decide, you know what, we need more than just a responsive website, but we need somebody to actually overhaul the whole thing. We need to make it, website, I don't know what we're at now, 4.0 or something like that. it needs to be more modern, and so they want you to do more work than what's specified. And again, this is when you want to make sure that you've got something in place to protect you from that, so that you don't run into an issue of doing work and examine that scope creeping that we run into. Either it's expanded or even sometimes new things will be brought in too. If the client comes to you and says a contract isn't necessary, just go ahead and trust them. That is also another big red flag. Again, it goes back to showing that they're not really willing to commit to you. They're not willing to commitment to the work. And so something like this, you're probably better off not taking the client in the first place if that's the case. But you never know that unless you had the contract in the first place that you were offering to them at that point. If there's a problem if the client brings in other people to the same work. So I don't know if you've run into the situation where you're doing a project for the client and then all of a sudden you find out that there's other people that are doing something very similar to that, or something that kind of borders on what you're doing for them. Again, this kind of goes toward lack of trust. They're showing you they don't really trust you. They don't trust the work that's being done for them. And it usually means that you're going to be fired here soon, and they probably won't pay. So this is when you definitely want to have a contract in place to handle what happens if they decide they want to pull the plug on you, to make sure that you do get paid for that work that you've done at that point. And of course, clients failing to make payments, you want to have something in place at that point too, that sets out your rights to collect the money for the work that you have actually done for them. Okay. All right. So before I get into what you want to have in the contract, there are a few kind of important things that I think that you should know about contracts. The first one being that they're there to protect both parties. So most of this presentation here, we're going to be talking about what we can do to protect you as the freelancer, as the entrepreneur. But the client also gets benefit because in the contract, it's clearly set out what you're going to be doing for them. If you're going to be doing a website, should clearly state in there, here are exactly what you're going to be doing for that website. If you're going to be drafting the copy for it, if you're going to be in charge of the images, if you're going to be doing any of the SEO for the website, anything like that, you want to make sure that that's in place so that the client knows what they're getting for, what they're paying for. So they're not surprised when you say, "Oh, all I thought we were doing is just the SEO for the site," and they intended you to be doing new copy as well as new images and doing some more significant changes for it. So it protects both sides, not just you on there.
I think as a freelancer, this becomes another selling point for the non-event, which is sending the contract, saying, okay, great, we agree to the scope of work. Let me get that into writing so that we both know exactly what's going to happen. And I'll send that over to you tomorrow, this afternoon, whenever.
Yeah. And sometimes, if client gives you a little bit of pushback, maybe like, do we really need a contract? Is this something that's really necessary that we go through that? Can we just get started? That's a good response, is that, hey, this contract is also here to protect you. So that way it's clearly set out exactly what you're going to be getting from me and what my obligations are to you. It's not just something for me. Again, don't work without one. Don't start the work without a contract. It's very easy to say, oh, I'm going to, we'll get the contract in place in a minute. It's not a big deal. We'll just get started. I can tell you from experience that 99% of the time, if you start doing the work before you have that contract in place, even if you have the best intentions to get that contract done, it's not going to happen because you're going to get busy with the work. The client's going to get busy on what they're doing. They're not going to think about it and just never going to get back to it. And by the time you're thinking about it again, either something terrible has happened or the project's over at that point. And so it doesn't really help you. So do it at the beginning. Again, it also is great because it sets out those expectations of what the client's going to get and then what you're going to be asking for them in return, and have that up front instead of waiting down the road for it. Don't blindly accept the other side's terms. You may get a contract from the client that they have you to sign, especially if your client works a lot with freelancers, outsources a lot of work. They may have a contract, a standard contract that they like to use, and you may be tempted to just sign it, and to kind of get through the work and to get going. But especially I've noticed the bigger the client is, a lot of the times they don't even actually know or really understand what's in the contract that they've got. It may have been drafted for a client for a specific circumstance that doesn't apply to you. You're doing completely different kind of work. It may have been passed down to them to a manager or a coworker or someplace like that, and the person you're dealing with doesn't actually really know what it says. They just know that this is our standard contract that we send out, and so you and they may be agreeing to something that, again, doesn't really apply to you, and it's not really going to be good for either of you in this circumstance. It's a process of negotiation where you each have the chance to go back and forth and to work out the terms so there's something that you both agree to. That's what really makes a contract fair to both parties. As I mentioned, it's not just we're looking to protect you, but this contract also is helping the client as well. And part of the way that they get that protection is by having input in what it says and what the terms and the language is that they use. To that point, always anticipate that there will be some sort of negotiation in your contract. You may have what you feel is the best contract out there, and it's wonderful and everything else, but invariably the client's going to come back and see something that they kind of want to change for whatever reason. The way they read it, the way they think about something, they just don't like the way it says and they want some changes to it. It's going to happen, so don't be alarmed when that does occur and come up. Don't let it take you back and think that they're totally, shutting you down, that they don't want to work with you. It's just, again, part of the process of making this contract fair. That said, you should have some points or know up front exactly what it is that is your must-haves or the deal breakers, things that you're not going to back down on, that they're important to you. Some things in your contract, and again, it'll depend on you and what you're doing, but it could be things such as the transfer of intellectual property rights. So when the client gets the rights to whatever you're doing for them, it could be regarding the termination provisions, how you can terminate, when you can terminate, payments and things like that upon termination, and then also liability shifting. So indemnification, making sure that you get protected in case something happens, in case the client comes back or a third party comes to you. Sometimes that happens when you've got, if you've been open source or if you're doing other code or things that you're bringing in and you're using that, there's the possibility that whoever owns that code or whatever that you're using, the software, could come back and raise an issue. You want to make sure that you're protected through the language of the liability in there.
Can you define the word, what was it, indemnification?
Indemnification.
Indemnification. I see that, and I've never known what it was. Can you define that?
Indemnification means that the other side is going to be covering you. So if there's liability, the other side's going to take care of it. They're going to pay for it. They're going to defend you against it. They're going to be responsible for that.
Got it.
Mm-hmm. Lawyers talk to lawyers. If your client brings in their lawyer to look over your contract, if you're in maybe a phone conversation or something with them and they bring the lawyer on the line, at that point, you need to get your lawyer involved as well. As lawyers, we speak a special language called legalese, and it's what makes things really long and complicated and hard to understand for a normal person. And oftentimes, we take that legalese and translate it and use it in our everyday speech as well, such as indemnification. And if you don't have a lawyer in place, you may not know what exactly you're going to be agreeing to when they're asking something or making points. And so if they feel that it's important enough to them that they bring a lawyer in, then it should also be the same for you. And again, this is a good point, regardless of whether you're in the process of negotiating your contracts or wherever it is in the process. If your client ever at some point brings in their attorney or says, I need to talk to legal about this, you need to be looking to lawyer as well on your side. And I know it's tough, but you really do need to be specific and confident about money. The work that you're doing as a freelancer, as an entrepreneur, is valuable, and you should be compensated for that value. Be confident in what the work that you're doing is work, and don't let the client negotiate you down because you're afraid you're going to lose them as a client. You kind of got to stick to your guns here. And that's, again, why it's a nice thing to have about the contract, where you can put it in place there. And once it's in writing, it's a little easier to stand behind it than if it's just strictly oral back and forth between you and them. You can kind of relay on and say, hey, you agreed to, this is the price up front. That's what we're sticking with. I'm not going to reduce the price now, down the road, if we've already been doing the work on that. Okay, so now the part that I know Jay and everyone else has been waiting for. We are going to go through these essentials for freelancer and entrepreneur contracts. Now, these are going to be general areas that either your contract should address in some way, or if it doesn't, that you need to have a good reason for it, why you don't have it in there. And there are some things in your situation, maybe that's not really important to you, and that's fine, but at least you have a reason why these things aren't in there. So I think now I'm pretty sure I see Jay feverishly looking for his notebook so he can write these things down. So again, feverishly, exactly. So again, these are kind of general areas. The specifics of what yours should say need to be customized to you. There's no such thing here as a one size fits all. And what one person uses, even if they're in a very similar business as you, it may be different than what you need for yours. Okay. So there we go. The first part of the contract is going to be the introduction. And the introduction of the contract is where you have usually the date, and also you've got naming the listing of the parties. Make sure that in this section that it is clear who the parties are. So if it's an individual or if it's a business entity, make sure that's in there, including if you're operating under a business. If you've got an LLC set up, make sure that it's clear that it's the LLC that is entering into this contract and you not individually. That's the reason why you set up the LLC in the first place, is to have it conduct the business for you. So just be sure that you've got the actual names of the entities or the individuals who are going to be the parties to this contract in there. I've seen contracts where you've got the wrong client name in there. Maybe they use a trade name or something, and it's not clear exactly who it is, and it can just run into confusion in individuals, or confusion in there about who exactly you're dealing with. So make sure that that's clear.
This probably goes without saying, but let's say I'm a freelancer and I use a similar contract between clients. And I have a contract with my business and Miller Law LLC, but now I'm going to work with some other company and I forget to find and replace the right name. That contract pretty much becomes null, right?
I mean, you still have an argument that, especially if they signed it, your client signed it, that they're bound by it, even though, because they should be reading it as well. But if I got a contract from you that has a different client's name in it than my own, it's going to affect the trust that I put into you. And it's going to make me right there. The first impression is, well, look, they don't have their act together if they can't even proofread this and make sure that they've got my name in there properly.
Good point. Be careful with the copy and paste.
That's correct. That's right. Make it clear exactly what work you're going to do for your client. I know we've touched upon this a little bit earlier, but if there's any wiggle room in the scope of the work, the client will take advantage of it. Again, new issues might pop up maybe as you're doing some work, you have discover some new issues. Let's say you're doing some coding work and they just wanted you to clean up the code and make it so that the website looks good on a mobile. But while you're doing that, you realize, hey, there's some bigger errors, there's some bigger issues. The code, the way it's written, is really affecting the SEO and the ability for them to get found on this. Obviously you want to point that out to your client and say, hey, look, there's some other issues in here that they're popped up. But that's not what they hired you for, and that's not what you agreed to do at the beginning. So you need to make sure it's clear that if the client wants you to do that work, that there needs to be either a change in the scope of that contract, or there needs to be a new contract where you're specifically stating, I'm going to work on this new work, the SEO work, digging the code for these sort of things, and you owe me and you owe more money for that work, because that's in addition to what we already agreed to.
Is that something, Brad, where you need a whole new contract, or is there like an addendum process? What would you recommend?
I think it really depends on the nature of the new work. If it's something that's kind of corollary, that's similar, you could easily add on to an addendum. We'll just say, in addition to all the previous work, you're also going to do this, and here's what the price you're going to pay for that work. That would be fine. If it is completely different work, that they either, maybe they find out that you, let's say that they wanted you to create a logo for them, and that was the initial contract. And then as you're kind of working on the logo, you're showing them some different variations and kind of narrowing down to the final version. They say, you know what? I love the work that you do. You wouldn't happen to do like actual website designs, would you? And you say, well, guess what? I do websites. That is part of the work that I do. And they say, great, we want you to do that. We want you to do the whole website using the brand, the logo you've created for us. We love what you do for us. In situations like that, I would say a whole brand new contract that says, I'm making a website for you now. Here's all the different terms and things like that. Here's what you're going to pay me for it. You want to make sure that it's clear what the obligations and the responsibilities of both parties are in your contract. So if you are providing something to your client, deliverables, whether it's, again, maybe you're a logo in various formats, maybe you're providing them code, for an app or something, whatever it is that you're actually giving to your client, make it clear in there exactly what it is that you're giving them, that this is what you're entitled to. You're entitled to a JPEG version of this, or a high definition, vector of this logo, or whatever it is. Make it clear what they're going to be getting from them. That way they know what to get. It also can help throw in a timeline, so that the client knows what the time frame is going to be before you get back to them. But that way it also helps set their expectations of how long that they should be waiting for you. So if you say, well, it's probably going to take me 3 weeks to go through this process, you're not going to have them come back the week after and after 1 week and say, where is this? Why isn't this done? Well, it was pretty clear here in the contract that it's going to be a 3-week process. It's only been 1 week, so simmer down. We'll get to you. We'll get to it. So that can be beneficial to have that in there as well. The other side of the coin, though, is don't forget to include your expectations of the client and what you need from them. Regardless of the work you're doing, you're almost always going to need some sort of information from the client. Maybe they have a branding guide that they need to provide you, so you can make sure that what you're doing fits within that branding guide. Maybe you need them to give you feedback. You've got logos you're shooting over to them, and you need them to look over them and respond with feedback, so that then you can make changes and adjustments and kind of go from there. Make it clear what you're going to be needing from them, what you're anticipating them, what your expectation is, and also what happens if they don't do those things. So if you say, I need you to look over these logos I send you, and I need you to get them back to me within, let's say, 48 hours. What happens if they don't do that within the 48-hour period? What happens if it's a week and you hear nothing from them? It needs to be clear that that's going to affect the timeline and your ability to kind of keep things moving. And it's not your fault if you are 2 weeks behind on schedule because you have to keep waiting for them to get back to you. So put in not only what you're going to give them, but what you expect from them to be giving you as part of your contract, the obligations and their responsibilities.
Brad, I feel like I've seen in contracts along those lines language like the client agrees to provide necessary assets in a reasonable amount of time. Like, I think I've seen that exact kind of clause. What does that mean? Is that actually doing anything?
So this is that legalese stuff we were talking about. Reasonableness is a gray area, but it's used and put in a place where it's really difficult to define what that might be from the circumstances. So if you are, let's say you say, we'll get back to it within a reasonable time, comments on the logo. If they get back to you within 24 hours, 48 hours, a couple of days, that's probably reasonable. If it's 3 weeks before they get back to you, that's not going to be reasonable unless there are specific circumstances, and the reasonableness allows for those circumstances to come in. It makes it makes it subjective, but it allows someone to come in and say, well, based on all the circumstances and everything else, that was probably fair that it took them 3 weeks. They had family that was sick, or a death. They had a vacation schedule that they told you about, and all these things in there. So it allows for flexibility in there, and oftentimes people don't want to get nailed down to specifics. So they'll use reasonable instead of saying 48 hours because, well, what if I can't do it in 48 hours? Am I in trouble? If you use reasonable, it gives you some flexibility and some wiggle room in that. So that's why you see that a lot.
Great.
It's also, if you can't agree with the other side, you can just say reasonable in there as well, as opposed to trying to nail down something if you can't hit the same number. So, put a section in there in your contract that says how you're going to deal with requested changes, revisions, or additions. Again, it kind of goes back to the scope question if they want to expand the scope on you, but maybe they are, they decide in the middle of the project that they need to make some changes to what they're asking of you, and they need you to stop what you're doing maybe and make something different with it, or they're going to ask for, we don't need quite as much now as what we had said we thought we did. Any kind of a change like that, something that's maybe minor, that's going to affect things. Make sure you have clear in there how that's going to be handled. When is a change order appropriate, and how that's going to affect the work being done. Are you going to give yourself time to look over the change order? How does that affect the price, for instance? What's the process for requesting a change order? If they need to make some changes, they have to give you notice in writing. Those kind of things are going to be in there. And it's just to kind of help protect you so that they don't all of a sudden spring changes on you out of the blue and expect you to implement them right away. This gives you some protection for that, because again, invariably some things come up and changes are going to happen. So it's good to have that in there. Everyone's most immediately important term is payment. So this is not only how much the client is going to pay you, but also how are you going to be determining fees? Is it going to be a flat fee? Is it going to be are you going to bill them hourly for the work that you're doing? Make sure it's clear exactly how that's going to work so they can know what they're going to be paying. Also, things you're going to want to put in there are like when the payments must be made. So do you require maybe an upfront deposit with them? Maybe 40% upfront or 50% upfront, then the rest, upon completion. Do you break down payments? Maybe you've got phases. You say, after the initial wireframe of the website, you owe me this much. Once we've gone through the copy, it's this much. Maybe have it broken down in phases or even in monthly payments. If you anticipate that the work will be done over a 4-month period, maybe you break down the payment over those 4 months and say it's going to be $1,000 every month until then. Maybe you just have it as, instead of doing it hourly, you do it like a monthly system, so that if it takes me 4 months, you pay $1,000 for every month. If it takes me 2 months, again, $1,000 for every month. Different options and things in there that you can put in. But the clearer you are about money up front, the more likely you are to get paid at the end.
Do you see situations where people put in clauses about late fees, or what happens if payment is late?
Yes, you should definitely put those things in as well. A lot of time, you may use net 15 or net 30. I would recommend against using due upon receipt, because that doesn't really mean anything. People get it and they like, okay, that's great, it's due now, and then they kind of put it on the pile and they get to it later. So be specific about it. If you want them to pay you within 15 days, then put in your contract that payment is due 15 days from receiving an invoice. Or if it's due automatically, make it that it's due on the first of the month, let's say, and make it clear that that's when it's due. And if they don't, you can put in late fees. You can charge interest. Just things like that you can put in there to help get them to pay, incentivize them paying you on time. You can also put in the reductions if they pay early. I've seen contracts where people say it's due in 30 days, but if you pay in full within 15, you can take 10% off. And that also incentivizes them to pay you early and get the money up front, as opposed to having to wait for 30 days or 45 or whatever like that. Always good things. Like I said, it's better to make sure you get it all up in front. It's just going to help you get paid down the road if it's really crystal clear in that contract how the payment's going to work. So when you create something for a client, whether that is a logo, whether that's website code, ownership in that thing that you've created belongs to you at the moment of creation. As a freelancer, you're not an employee, so you don't have that employer owns my work sort of deal to worry about. So it's important that in your contract, when the ownership rights of that logo, code, whatever it is, transfer over to the client, because ultimately that's what they want. They want this deliverable, whatever it is that they're buying. But you also want to make sure that you get paid. And so one of the recommendations that I often make to clients is to make it clear that IP, the copyrights, the ownership interest, and whatever it is that you're giving them, that does not that remains in with you as the creator until final payment's received. That gives you really strong motivation for that client to pay you, because they know that until you get fully paid, they're not going to get the rights to use the logo or the website copy or whatever it is that you're doing. Too many clients, freelancers will basically, as soon as they're done, ship it off to them and say, here you go, here's your code, and here's my invoice. That's great, but at that point, the client doesn't need you anymore. They've got what they needed, so there's no incentive for them to pay or to pay promptly. But if you're like, all right, we're good, you approved it, all right, I will give this to you as soon as I get a check in my hand, you better believe they're going to get that check to you quickly. And so that can help incentivize fast payment and just payment in general, by requiring that you keep that IP until you get paid in full on that. Similarly, you might also want to put in some ability if you've got a website or you want a portfolio for logos, for instance. If you do a website, you might want to also get permission that you can take the logo or the website, the samples and things like that, and showcase as part of a portfolio. And so you want to make sure that you mention that in your contract as well, because again, once you transfer ownership interest, you no longer have any rights in that whatsoever. So they could say, no, you can't use that. And if you didn't have that language in there that gives you permission to use that as part of your portfolio, and you still did, they could go after you, basically for stealing their work at that point. So if you want it to be able to use it, make sure you just stick that in there. Most clients are fine with it, but it needs to be in there just in case. Either party, this is a business relationship, and so you need to make sure that either party should be able to get out if necessary. Things come up both on your side and their side where it may not make sense to continue working. Maybe they're really slow on payments. You have concerns whether they're not going to pay you in full at the end, and so maybe you want to get out now while you can before you put too much work in. Maybe there's a dispute over how the work should be progressing. Maybe they're showing signs they don't really trust you. They're micromanaging what you're doing. Maybe they just don't like what they're seeing from you, and they don't think that you're doing great work, and they want to move with somebody else. Whatever it is, you need to make sure that it's clear how and when each side can terminate. Make sure you also are getting paid for your work, though, in this, for everything you've done up to that point. If you've already, gone through 3 iterations of a logo, make sure that you're getting paid something for that work that you've done for them, because even though they may not have a finished logo, they still are getting value for that. The process they went through, the ideas that you presented them, things like that, there's still value in that. So make sure that you get paid for that work and that value that you provided them up to that point. So termination is really important that that's in there. So the legal stuff is all those provisions in there that we lawyers draft up, and they're really complex. They're really wordy. They're probably hard to understand, but they're really important, and that's why we put them in there. We kind of talked about some of these things previously. So that's things like liability, indemnification. What's a default? So, if they fail to pay within 30 days of an invoice, is that considered a default? At that point, can you stop work? Can you then sue them or go after them, legally for the balance of they owe you? What does all this look like? And then what's the consequences for that? I always recommend that if in your contracts that you throw in a provision in there that allows you to get your attorney's fees. So if let's say you do all the work for them, they love it and everything else, you give them the final invoice, and then they disappear on you, and you have to go after them and sue them to get paid. And unfortunately, that does happen at times. It can get expensive to try to go after that money. It may be only a couple $1,000s, and you may be paying at least that much in attorney fees to try to get that money from them. If you've got provision in there that says that you are entitled to your attorney's fees and expenses, then you can have them pay for your attorney to collect. And that way you're not coming out of pocket and having to come out behind in some cases to get them to pay you at that point. So attorney fees provisions is a good one to have in there. And it can get things moving a lot quicker for you. And the last section is signatures. So at the very end of your contract, you've got your signature blocks, and you want to make sure that both you as well as your client have signed this. If you are a business entity, so if you're an LLC, for instance, make sure that you sign the contract in the name of the LLC. If you just sign if it just has a blank line and then you sign your name on the blank line, you could be held personally liable for the obligations and things on the contract. And really that defeats the whole purpose of setting up the LLC in the first place. So make sure that if it is you as an entity, that's clear that the entity is the client and that you are signing it on behalf of that client as the owner, as manager, whatever it is that your title is, CEO, whatever you want it to be. And so it's clear that it's entity, not you personally, doing that.
Can you give me some more detail on that, Brad? And we can even use me as an example here. I send a contract on behalf of Unreal Collective LLC. I don't sign my personal name. I should sign Unreal Collective LLC.
So in the signature block, what you want to have is generally what I'll suggest is you type the name of the entity. So whoever the client is. So in this case, it would be Unreal Collective LLC. And then you've got the signature line. And then underneath it, I usually put by, and then your name, and then your title. So in this case, it could be by Jay Klaus, head honcho and president, for instance, whatever your official title is for the entity. And that way it's clear that it's the entity, but you as a person, obviously a person has to sign it. The company can't sign it. Okay. You are signing it in your official role under that company, president, CEO, whatever.
I did want to go back to something you had right before this page. I didn't unmute my microphone fast enough. The legal fees provisions, I think that's worth touching on. So you are within your rights to create a section on the contract to say, if you default on payment and legal action needs to be taken, the client assumes the cost of my legal fees.
Yep.
That's good news.
Yeah. Yeah, no, and I mean, and that's again a little bit more incentive for them to pay you, because they know that if they have to be chased down, that they're gonna have to pay for those costs. I mean, if you look in any contract that you enter into, you'll probably see that same provision in there. If you look into car loans, you'll see that if you default and the bank has to go after you for the car loan, you're going to have to end up paying the court costs and collection costs to go after it, for them to go after you. And so there's no reason why you shouldn't take that same protections and place it in for yourself as well.
We just got a question about the signature line from Tessa, who I think she asked pretty much the same question I did. Let me see if this answers it, Tessa. She says, could it be signature of the WildPath representative followed by WildPath representative type, name, and title? So to me, it kind of sounds like sort of the same question. So she could type the WildPath as her business. Okay. So I think she got it answered. She said typed right before you sent it. So I think that was the same question.
Yeah. Like I said, the best and safest way I think to have it formatted is the name of the entity. So whatever that is, underneath there you've got your signature line, and then by your name printed out, and then your title, and then you sign that way so that it's clear that you're signing on behalf of the company that way. So
wonderful, thank you.
Yeah. And the last point I've got on there is that electronic signatures can be your friend. They can be very quick. You can shoot over an email or electronically send over to a client a contract. They can sign it, get it back to you within a 5-minute period. You don't have to send them over something, then they have to print it out, and they have to sign it, and they have to mail it back to you, or and go through the whole process. It's going to take a couple days to do. Electronic signatures get things done faster. There's companies out there. I think Adobe's got stuff you can do. I've used stuff by HelloSign, but they all allow you to do some online electronic or digital signatures. And a digital signature is valid just as a written wet signature would be. So definitely green light to using those.
Is there anything specific that needs to be done for an electric signature to be done? Like, for example, using DocuSign or Adobe sounds like I would just kind of trust them that they have stuff in place. But if I sent somebody a fillable PDF and they just typed in their name and like the fill on a PDF document, does that have enough, or is there some like electronic timestamp that needs to be on it? How do you?
No, it's a continuum. So on the one hand, you've got your Adobe stuff, which tracks emails and when they sign it, when they received it, and through their servers, and it tracks all that stuff down. And they give you a lot of these at the end will give you a little log, and it'll show you here's when it was received, here's when they read it, here's when they downloaded it, here's when they signed it, here's when they submitted, all this kind of stuff. And so it's easy to check and to track that yes, they in fact did it. So that's kind of on the one hand. On the other hand, it would be no different than if you just had them print it off, sign it, and then maybe email it back to you. Maybe they scanned it and emailed it back to you. That's valid. Basically, any way that they're making an indication that they're agreeing to it. And if you come and you say, look, you guys have signed this contract, here's you typed in your name or whatever to start working, and so I'm going to try to hold it against you. It's up to them to then argue that they didn't actually sign it, that's not their signature or whatever. The bird at that point then switches to them that it's not valid.
Got it. Great.
So, all right. And so that is what I've got. I think we'll open up to any additional questions here.
Guys, feel free to enter any questions into the chat or ask a question. We did have a question earlier from Anna, who unfortunately had to leave, but we'll answer it for posterity. Prosperity?
Posterity.
Posterity, okay. Her question, which I think a lot of freelancers probably feel in this boat, what if you feel as though you can't afford to bring on an attorney if you're just starting out? What is, maybe answering that is, what is the bare minimum that you should really make sure you have set if you have a small budget for an attorney? Or I'll just let you answer.
Yeah. So again, being a small business owner myself, I definitely understand the idea of kind of bootstrapping and of trying to allocate your resources to where it's going to make money for you and when it's going to make the most sense. And being a lawyer, I admit I will come across this a little biased, but I really see that investing in legal services as an investment. It shouldn't be seen as an expense, because if you come to an attorney and I set up an LLC for you, let's say, that could protect you from if somebody tries to sue you down the road for, a couple $1,000s for work that you've done. That could protect you from that. For a small investment up front, it's got a bigger, potential payoff down the road of protection. Same thing with this contract. You could have a contract drafted up, have an attorney draft one up, and basically create a template for you that then you can use for every client you have after that. You can have some blanks that you can fill in for specifics about the projects, but you can have it set up so you can use this contract for every client you've got thereafter. You're putting a small chunk down for all the value you're going to get, because you could use it for years and years until you start to grow bigger, you change your business a little bit, you bring on people, things like that. And so, it's easy to say, well, it's a lawyer, I don't want to have to spend a couple $100 to have this stuff done. I'm going to put it towards marketing or something like that. But I really do think that it is important that you really consider, much like insurance, that this is something that you put a little bit down now, and we're looking to see benefits down the road and protection and peace of mind. You're not worried about something happening, road, because you got this in place now. So that's my biased lawyer spiel. That all being said, I think you want to, if you're going to get an entity set up, that's something, depending on the state you live in, the jurisdiction, that might be something you can do yourself. I know here in Ohio, that's something that, you can do on your own pretty simply and get it set up without too issue. I would definitely say, though, for the contract, you probably should have that done by a lawyer. And the price for that is going to vary depending on the lawyer you use. If you use someone in a small firm, a solo lawyer, you're likely to spend less. If you go to someone in a bigger firm, you're going to spend more.
And I will say, I just put a link to Brad's Medium in the chat where he wrote a piece about how lawyers charge. So if you have questions on that, go there. We only have a couple minutes, and so I wanted to ask you a couple things that are a little more specific. Not like too specific, but one being, let's say I'm a freelancer who has not been operating with a contract to this point, and I'm having an issue with a client who agreed verbally or maybe even in written email to a scope of work and a price, and they're not paying. Do I have any recourse if I do pay for a lawyer or go to small claims court?
You do. An oral agreement is still valid. Email is still written evidence of a contract, so emails can be kind of a sign of a contract. Obviously, it's harder. It's more difficult because you have to get everything together. You have the burden of showing what the actual agreement was at that point. Whereas if it's in the contract, it's all pretty much just laid out for you, and you can say, "Here's what it was. Here's what we agreed to," as opposed to trying to go through email threads and figure out exactly, okay, now where did they agree to say this? Now, did this get changed later on? Did they say something different? But it is still kind of something you can. That's all you have. I would definitely say, again, take what you got, go to a lawyer and let them help hash through what you've got.
Okay. And we just got one question here from Alexa, who says, if I was in my apartment, my Amazon Echo would be going off right now. I stopped pause. I'm like, oh no, did I do it? Nope, I'm in a co-working space. Her question was, what about services like my invoicing software that have contracts built in and are marketed as written by lawyers? She uses something called Hello Bonsai, and there's a ton of other softwares. Can those softwares be trusted that kind of generate contracts for you?
So I think that what she's referring to is, and definitely, correct me if I'm wrong, but a situation where you are paying for this service, and as part of that, they are basically saying, here's a contract that you can use and we'll have you use for your client. Is that the situation here?
Alexa, feel free to chat type in the chat to say if we're on track or not. A lot of these softwares do have like this invoicing built in, so I'm guessing there's something like that.
Yeah. Again, assuming that that's kind of what you're talking about, those things, again, the problem that I've got with those are they're not customized to you. So yes, they're going to have some of the language in there that deals with indemnification, perhaps. They're going to have some of the maybe some of the IP language in there that says that you own some of the IP until payment's been made. Some of that stuff might be in there, and they were drafted by lawyers, so that's going to be better than something maybe that you and I, with no other background might come up with. But again, it's that idea of a continuum. You've got something that you kind of drafted and come up from scratch. On the other hand, you have something that you went and sat down with a lawyer and they came up with you custom, just for your business. Going through a service like that and getting one that's lawyer drafted is better than one that, you just kind of put together yourself. But I definitely say it's not nearly as good as one that would be custom to your business, to your needs, and things like
that. And Alexa, maybe you know this better than we do, but things that you mentioned with, timelines and the scope, you'd have to be able to enter that custom into the software. So it could be customized to you, whereas it may be sort of like
some of that stuff. Yeah. I mean, some of the specifics about the projects and things like that specifically, that's probably fine, because that stuff you're going to have to add and change anyway by the project. But some of the legal terminologies and things like that. The other thing is a lot of those aren't state specific. So they'll have a lawyer who might be in New York or Florida or California or someplace like that. And so they kind of have to be general about it. And they may say, oh, it's valid in every state, but that's just because it's so general. There may be specific protections in your state that you can use, or things you can't do, and things like that they're not going to take into consideration.
Well, Brad, I want to be respectful of your time. Thank you so much for sharing with us. This is awesome. We will be sending out a replay of this to everyone on the webinar, so you can go back and refer to it whenever you'd like. But you can meet with Brad. You can communicate with Brad on Twitter at Bradley Miller. His Medium, I posted in the chat. His website is bradleymillerlaw.com. And great. Do you have anything else that you wanted to shout out or ask of the audience, Brad?
No, like I said, I just, I think it's important that you've got something in place. Just again, for your own protection, this is your business is probably your most significant asset. And so I think it's worth taking the time, taking some money and really make sure it gets protected.
Great. Okay.
Something happens to it.
Well, thanks, Brad. Thanks everybody for listening. Feel free to share this video with people you think it would be helpful for, other freelancers and entrepreneurs. And we'll talk to you next time.
Thanks, guys.